about criminal law. In Australia, as is the case in most jurisdictions throughout the common law world, criminal law is the law of punishment. Statute in Australia, both federally and at a state level, defines criminal offences, regulates the charging, trial procedures and sentencing elements of the system, and attaches to it penalties and varying modes of treatment for offenders within that system. The concept of criminal law is that society and the greater public can be or should be protected or shielded from certain behaviours by the implementation of a system of laws that seeks to deter people from committing offences that are a threat to the continued functioning of society. Criminal law faces challenges not necessarily faced by other disciplines. This is largely as a result of preconceptions concerning civility, crime, and punishment. For example, people might generally tend to have very strong views about sex offenders and whether those people charged with such offences should have access to justice. We are taught, of course, that natural justice and procedural fairness are the cornerstone of the Australian legal system, but this is not a view shared by all. Of course, this is an extreme example, but it is one that can be extended to other offences, mostly because it is a view not based on a holistic approach to justice or equity. Furthermore, the concept of justice in and of itself is subject to value judgments and is often predicated upon black and white understandings of the term. As we know, the justice system is subject to the same prejudices and shortcomings as any other discipline. We can see this in, for example, the way in which systemic racism or paternalistic approaches to the law have led to greater incarceration rates for Indigenous Australians more so than any other demographic in the world. This is further exacerbated by the fact that within this system, those enforcing the law, making decisions, or defending those accused of offences are human beings who often face moral and ethical dilemmas in practice. Strict adherence to personal values concerning what is right or wrong can be useful, but the human factor of the criminal justice system can be overwhelming. What's more, defence lawyers are often placed in positions whereby they have to advocate for clients who they know are guilty. The defence lawyer, therefore, walks a fine line between behaving in a manner that is consistent with being an officer of the court whose obligation is to uphold the institutional integrity of the judicial system and advocating for their client in a way that is in the best interests of the client.
On the 1st of June 2020, Lisa, a stay-at-home mother, is out at the park one day with her daughter, Faith, and her husband, Alec. A man, James, is sitting nearby with his girlfriend. Lisa sees them together. She walks over and stabs James multiple times over his upper body. James dies of his wounds. Lisa is charged with the murder of James. Lisa tells you that she did not know James. He was a stranger and she doesn't remember stabbing him. She claims to have blacked out. Lisa wishes to plead not guilty. During the trial, Lisa's husband, Alec, testifies that his wife has never been violent in the time that he has known her, or in her life for that matter. She is a loving and caring mother. As the trial progresses, Lisa confesses to her lawyer that she knew exactly what she was doing, and that she stabbed James because she knew him. In fact, James had gotten her pregnant in October 2011, and he had left her and claimed the baby wasn't his. Lisa was subsequently kicked out by her parents and she suffered a miscarriage in December 2011. After her miscarriage, Lisa developed a drug habit and was convicted of 2 assault charges and 1 count of larceny in the years 2012 to 2013. Lisa then sobered up and changed her name and met Alec 2 years later. They were married in January 2016. The defense has entered a plea of not guilty on the grounds of sane automatism, arguing that Lisa's actions were involuntary and supported by the fact that she had no prior connection to James. The prosecution has not brought to light Lisa's past convictions. Let's have a look at the key stakeholders in this scenario.
Now that we have identified who the major stakeholders in our hypothetical situation are, we can turn to what their interests are and how they might be affected. Lisa, our client, has engaged a defence lawyer because she requires, and rightly expects, that she will be represented in an ethical, objective and professional manner. Also affected are those who are seeking justice for the alleged offence committed, namely the murder of James. Those who seek justice expect justice, as is, of course, both fair and reasonable. Finally, We have our defence lawyer, whose role in this fact pattern poses numerous issues, both real and perceived. Importantly, our defence lawyer is faced with the problem of having to make decisions about criminal defence strategies with full knowledge of the fact that Lisa was dishonest in the pleadings and has entered a defence that cannot be sustained or argued without breaching various rules and personal ethical codes.
To address the ethical concerns in our problem scenario, we are going to use the Parker and Evans 3-step model. The first step is to identify ethical issues.
Next, I will talk about the application of the relevant case law, statute, and rules to these ethical dilemmas. The first dilemma relates to the representation of a dishonest client. In this scenario, there may be a conflict between the lawyer's personal moral value and Lisa's plea of not guilty, because her confession of guilt has made the allegation inconsistent with the morality of an ordinary person. However, according to the principle of neutrality and non-accountability we learn from Class 6, a lawyer is required not to be affected by their personal sense of value, and his or her action should also not be evaluated in ordinary terms. So, it is not a breach of professional standard if the lawyer still represents Lisa even she or he knows she is guilty. The solicitor rules also apply here. Lisa has lied to the court and the lawyer before she made a confession that she did not know James, which satisfies Section 20.1.1. Because the lawyer has now been informed of the truth that Lisa had a motive for killing James, she or he is not allowed to deceive and unknowingly mislead the court by arguing that Lisa did not know James before, which is required by Section 19.1. As mentioned in Section 20.1.4, the lawyer is also required to advise Lisa that the court should be informed of the lie and suggest her to give authority to disclose the confidential information, including the relationship and the crime records, in order not to breach the duty of candor. Section 20.1.5 requires that if Lisa does not agree, the lawyer will be prohibited from disclosing the confidential information, or she or he will breach the duty of confidentiality and may be convicted of professional misconduct. In a previous case in New South Wales, a solicitor was struck off the roll for professional misconduct because she sent an email containing confidential information about her client, her dishonesty, and discussed matters relating to the client in a derogatory way. While our case has facts more extreme, there is no doubt that client confidentiality is the cornerstone of the legal profession.
Next, our group will talk about the case law in accordance with ASCR Rule 20.1, the cogent responsible lowering and fairness justification for the restriction on the truth, as the case of Takia present. In Takia's case, the lawyer did not disclose any confidential information about whether the client had already confessed. However, the lawyer told the judge in front of the jury that he was in the worst predicament of his career. In this way, he implied that he was defending a guilty client who was likely to be executed for his crime. His action potentially revealed to the jury the sentiment his client revealed to him in confidentiality. On appeal to the High Court, there was an unanimous decision that advocates are bound to keep silence in such circumstances and continue with fully testing the prosecution's case, although they must avoid putting their clients in the witness box to give affirmative evidence of innocence. Counsel's statement in front of the jury constituted a substantial miscarriage of justice, and Takia was released. From this case, we can see that the duty of confidentiality binds advocates' actions, providing that no active misleading of the court occurs.
For lawyers' accountability, Section 90.2 requires the lawyer to correct any misleading statement to the court, and Section 20.2 applies that since the plea of not guilty has been entered before the confession, the lawyer cannot argue Lisa's innocence based on her involuntary action and lack of a pre-existing relationship with the victim. The lawyer is also unable to allow false facts if she or he knows, or make any false submissions to mislead the court. This is required by the Section 19.2. The lawyer is only able to expect that the prosecution is unable to prove beyond a reasonable doubt that Lisa is guilty in this scenario. But consider, is hoping for that possibility inconsistent with the principle of acting in the client's best interest? It just might be, we think.
That if the lawyer would like to withdraw from the case, the High Court explained this Takia's case by using ASCR Rule 20. The objective of this rule is to ensure the continuing prosecution is as fair as possible. The hesitating clients usually consent to disclose the lies when they realize the effective penalty for non-cooperation will be the withdrawal of the advocate from the trial. When the lawyers withdraw, they must formally advise the court of the reasons why they withdraw. Some jurors might be affected since they were anxious about avoiding seeing that the defendant will escape from the guilty verdict. In this case, Lisa's lawyer should learn how to avoid this kind of influence if she or he attempt to withdraw from the case.
Let's look at Section 13.1. The predicament here is balancing duty to the court and the duty to act in the best interest of Lisa. Relying on subsection 3, it suggests that an effective standard to follow may be to withdraw from the case and advise Lisa to seek help from another lawyer. This will be the case especially if the client insists on pursuing a frivolous course of action, which would pervert the course of justice. Section 9.1 requires the lawyer not to disclose the confidential information except as permitted in subsection 2, which cannot apply in Lisa's case. The confidential information about the previous relationship between Lisa and James and the criminal records is crucial to the allegation of involuntary act from Lisa and subsequent judgment for her offense. Lisa did not offer authority to disclose, and the lawyer has no statutory obligation to disclose. Lisa's action here seems inconsistent with her general character as a loving and caring mother, but the stabbing incident does not preclude any further violent behavior from ensuing. Lisa, however, is in custody and is at no risk of carrying out another crime. It is arguable that by disclosing the confidential information, the lawyer will breach the duty of fidelity and may be accused of professional misconduct. Section 3.1 has defined the duty to the court as a paramount duty, which will outweigh the duty to the client if any inconsistency exists. In the case Randall and Worsley, Lord Denning also explained further that lawyers should disregard the instructions of their clients if they are inconsistent to the duty of candor. They should help the court to discover the truth and disclose the relevant documents if ordered, even if they are fatal to the case. As a result, the duty to the court should always come first compared to the client's loyalty.
Does a defense lawyer have to disclose a defendant's prior convictions when the prosecution has failed to do so? Previous convictions lessen the client's credibility and weaken the plea of innocence entered. A general principle exists where the defense does not have to disclose a client's adverse criminal history to the court. The Solicitor Rule 30 instructs the lawyer not to take advantage of obvious errors by the opposition, but the fact remains that it is the role of the prosecution to prove the facts at issue, not the defense, who has a duty to act in the best interests of the client. Therefore, the defense lawyer does not have to disclose the prior assault and larceny convictions of the client.
First, the lawyer could persuade the client to change her plea of not guilty to guilty and undertake a plea bargain with the prosecution. A plea bargain allows both parties to avoid a lengthy criminal trial and may allow criminal defendants to avoid the risk of conviction at the trial on a more serious charge. According to the R versus Hall 1968 2QB, if the accused wishes to change his or her plea from not guilty to guilty, the judge should always grant leave. In appropriate cases, the judge may need to be satisfied that the plea is made voluntarily. There are still issues on applying this measure. For defendants whose conviction is almost certain, a commutation of the sentence is more useful than an unlikely acquittal. In this scenario, the client was seeking for acquittal, and she could unlikely agree to change her plea of not guilty to guilty. Defense attorneys are required by the ethics of the bar to defend the present client's interests over the interests of others. Violation of this rule may result in a disciplinary sanction being imposed against the defense attorney by appropriate state's bar association. Another action is to change the defense from sane automatism to insane automatism. This would effectively argue that Lisa's action was an out-of-character decision, imbued with traumatic memories from her past. Continuing with the current defense of sane automatism would lead the court. This measure contains a high risk, for a lawyer lying in the court is a serious crime, and the defense must change due to the change in facts. The focus is to act in the client's best interests and to get the best possible result for her based on the current facts. The lawyer should advise the client of resulting ethical conflicts if she wants to continue with the current course of action, and the lawyer may have to withdraw from the case if she maintains her position. Which brings us to the last and most unfavorable course of action: to withdraw from the case. An advocate can continue to act for a client under such circumstances, provided they confine themselves to testing the prosecution's evidence and avoid leading affirmative evidence of innocence. However, difficulties may arise when a lawyer withdraws, as they must do so without giving away the reasons for which they have withdrawn. It is possible that the jury may construe the withdrawal of their advocacy as a presumption of guilty. Changing the defense to a full defense of insane automatism could lead to a verdict of not guilty. Because of the mental impairment, which is arguably what happened here. Pursuing the current defense is not possible based on the statements that were relied upon, misleading statements that imply the innocence of the client when she is in fact guilty.
Parker and Evans' 4 approaches to legal ethics provides us with an overview of the kinds of behavior the lawyer must exercise based on perceptions of morality and principles of the legal profession. On two sides of the spectrum are the adversarial advocate and the ethics of care approach. Which approach is more fitting here? The adversarial advocate is arguably the most traditional view of what a lawyer should be, a zealous advocate for their client, employing tools such as the principle of non-accountability, partisanship, and the standard conception. In Lisa's case, such an advocate would do well to represent the best interests of the client, but what of personal moral sensibility and duty to the court? We like to think our lawyer has a bit more heart, and so we turn to the other end of the spectrum, ethics of care. This approach preserves and prioritizes relationships above impersonal justice, but it doesn't seem to fit here. We need an approach with more substance. Enter moral activism. This approach embodies what we decided to do in the end, which was convince the client to do the moral thing. Remember that lawyers cannot escape moral accountability by being an adversarial advocate. We must act with substantive justice in mind, influenced appropriately by social and political issues.